Hi, this week the discussion is about the power of the courts over administrative agencies. In a nutshell, this chapter is about due process, which allows for judicial control and review of what administrative agencies do. You can also think about this week we will focus on the 14th Amendment. The courts review the decisions of an agency in the same way it does a case on appeal. As you may recall, I am a hearing officer for the Illinois Toll Authority. The decisions I enter can be appealed to the Circuit Court of DuPage County. The court will assure that substantive due process and procedural due process was assured. As I mentioned in the previous slide, due process is a focus of a judicial review and administrative agency. Substantive due process is about whether the law is fair and clear. Procedural due process is about whether the agency followed the law. For example, in the hearings I preside over, I cannot change the fines issued on violations. The Illinois General Assembly established a statute limiting, or I should say identifying, the fine of $20 on every toll that is missed. So if I entered an order for toll payments only, the toll authority would appeal the decision and the Circuit Court of DuPage County would determine that I did not follow the Illinois law that established the fine. My order would then be vacated. Remember that due process involves procedure and whether or not the law itself is fair. When you think of procedural due process, think about that procedural due process assures that litigants are given proper notice to the proceedings and a right to a hearing presided over by a fair judge. Next week we will discuss case law that helps us understand what kinds of issues have a right to a hearing. Which brings me to the focus of this week, which is equal protection that is established by the 14th Amendment to the U.S. Constitution. The 14th Amendment, or equal protection, is about equal access and equal opportunity. Equal protection does not mean the same treatment, it means equal access and equal opportunity. For example, the American Disabilities Act provides that people with disabilities shall be given equal access to all public facilities. But what does equal access actually mean? A person who is in a wheelchair may not be able to enter all of the entrances to College of Lake County, but the person in the wheelchair has access to most of the entrances to College of Lake County. However, people who are not in a wheelchair can enter at any entrance. Are they treated the same? No, because some can enter at any entrance and others can only enter at some. However, the two groups are given equal access, although they are not treated the same. That would meet the requirements of equal protection. Again, it does not mean always being treated the same. It is about giving or finding ways to give equal access. So maybe you are thinking, then what or how can a court determine if the nature of the law or a policy of an agency provides for equal protection, or some people like to call it provides for fairness? Remember, this is a requirement by the 14th Amendment, and it's a due process requirement. The court will use three tests: strict scrutiny, rational basis, and middle scrutiny tests to determine if the law is fair. The table in the PowerPoint explains how the tests are applied. The issue arises when the law applies to certain classes of people, then the test is applied and the analysis is based on the application of the test to the facts. For example, if the agency has a law or policy that treats people differently based on race or ethnicity, or the agency is infringing on a fundamental right, which is a right that arises from the U.S. Constitution, then the test the court will use is called strict scrutiny. That means the court is going to look at the nature of the law or policy and critique it in so many ways to the extent that the government must establish that the law was needed for a compelling government interest. And having that law is pretty much the only way the government can obtain that particular interest. So laws that treat people differently on the issue of race or ethnicity or even religion or infringes on freedom of speech can be constitutional if it meets the strict scrutiny test. Likewise, if a law treats people differently based on gender, then the court has to give it, or the law has to pass, a intermediate or middle scrutiny test, which means the government must have some substantial goal that the law is tailored to meet. If the law is not tailored to meet that goal, or if there are other feasible ways to meet that goal, then the law will be determined unconstitutional. And all other categories fall under the rational basis. For example, sometimes people say, can smokers be treated differently than non-smokers? And the answer is yes, and that would be given a rational basis test. Is there a reason under the law or a goal of the government to require smokers to smoke within a certain distance from the school, while certainly non-smokers are not required to follow that? Arguably, any class of people falls under that particular law. It doesn't matter age, ethnicity, race, religion. Doesn't matter for the application of where smokers must smoke. But the law is treating really classes of people differently, smokers and non-smokers, and arguably it is treating businesses different because the tobacco industry, their products are limited in their use by the nature of the law. So the test that will be applied is the rational basis test, which is an easier test to pass than strict scrutiny or intermediate scrutiny, which makes sense because the categories that fall under rational basis, the law or policy itself does not appear to be treating classes of people differently based on who we are or the faith that we have, and the law is not infringing on a constitutional protected right. So let's think about admissions process to colleges. Some people think that admissions process to colleges are based solely on grades and test scores. And while grades and test scores are the major factors, other factors are used to determine which students are granted admissions and which ones are not. For example, if you think about the process, a school like University of Illinois might have 10,000 applications for 3,000 freshman seats that they're going to extend acceptance to. Arguably, more than half of the applicants meet the required GPA and test score. So if you have 5,000 qualified applicants, how do we narrow that pool down to 3,000 freshman seats? And that's what you see in the slide is perhaps the University of Illinois is using a plus factor system to try then to determine which of those applicants are then admitted into the school. That's a way of narrowing down their application pool. However, this process is going to meet some challenges. The University of Illinois established an admissions process that grants plus factors to applicants for having 1. Alumni parents, or 2. The applicant is a member of a specific racial group or racial groups, or 3. The applicant lives in a household with family income below the poverty line. Those students will be given points to aid their admission process. So granting points for having parents who are alumni is a general classification that is discriminatory against those applicants who don't. Because they won't get the points. Is that fair? The rational basis test has to be given to determine is that fair. Likewise, in the Illinois admissions policy I posted or made up for this hypothetical, the institution is granting points to applicants of specific racial or ethnicity groups, which is discriminatory on its face against students who are not members of those groups. The question is that fair? And the answer will be based upon the application of the strict scrutiny test. To determine if the answer is yes or no, we'd have to have more facts about what is the objective or the reason that the University of Illinois would need that kind of law or policy, because for the school to do that, that would be some law or policy of a public institution. It would be given a strict scrutiny test. Likewise, the same policy is granting applicants who are from families with income below the poverty line. That treats students or is discriminatory against applicants whose families' incomes are above the poverty line. Is that fair? The rational basis test will be given to determine whether or not it is fair. So hopefully that gives you a way to begin thinking about how these challenges arise, or what an agency does that, and this could happen even with a state statute, that requires the test mentioned in our chapter to determine whether or not a law is fair or constitutional. So just think about some other types of laws that this could create a challenge. A city imposes a fee for parking trucks in a public parking lot, but cars are not assessed the same fee. Again, it doesn't matter about who the people are, but truck drivers and car drivers are treated differently. Rational basis test. A fire department only allows men to respond to fires. That's an intermediate or middle level scrutiny test, because it's treating people different on the basis of gender. A state social agency only allows women to interview victims of sexual abuse. Again, this is a gender discrimination, so the middle scrutiny or intermediate scrutiny test will apply. Whether or not the law withstands the challenge is really based, again, on what are the objectives or the compelling interest of the government itself in passing those laws. So you learn that in this chapter, if you haven't already, was not already aware of this, some laws or policies in our society can treat us differently for various different ways, but they must pass this test, which is another way of saying there's a justifiable reason to infringe on our rights in the way that the government is infringing. All right, then that brings us to your homework assignment. So for this week, you will work on the practical applications 1, 2, and 3 of page 259, and that will allow you to use the material in this PowerPoint in your homework assignment, and we will complete the second part of this chapter next week. So contact me if you have any questions or concerns. Otherwise, good luck.